stand and join me with the pledge. Old Lori's here in the left corner. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. I'd like to introduce our speaker this evening. Publius is a former judge advocate, retired litigation lawyer who lives in Tennessee. Before getting a law degree, she got a degree in philosophy, where she specialized in political philosophy and theories of knowledge. She now writes and speaks throughout the U.S. on the U.S. Constitution, using the Federalist Papers to prove its original meaning and intent. She shows how federal judges and politicians have ignored our Constitution and replaced it with their personal opinions and beliefs. She also shows how the people can, by learning our founding principles themselves, restore our Constitution Republic. So with that, I give you Publius.
Thank you. We are in the final stage of a takeover. All that's needed is a new Constitution. Leftists of every variety want a new Constitution to legalize the transformation from a constitutional republic created by this to a dictatorship. To get a new Constitution, they need a convention. So they are telling Americans that our Constitution is causing our problems and we need to amend the Constitution. And they say we can only make the needed amendments at a convention. So tonight I will tell you of the plot to impose a new Constitution under the pretext of amending our existing Constitution. Article 5 of our Constitution provides two methods of amending our Constitution. Congress proposes amendments or calls a convention to propose amendments if 34 states apply for it. The first method was used for our existing 27 amendments. Congress proposed them and sent them to the states for ratification or rejection. Under the second method, Congress calls a convention. We have never had a convention under Article 5 for good reason, as you will see. But the left has been pushing for a convention for 50 years, ever since the Ford and Rockefeller Foundations produced the Constitution for the new states of America. Read this and tremble for your country. It sets up a dictatorship. In the past, conservatives defeated these pushes for a convention. So the left changed tactics. This time they are marketing it to appeal to conservatives. They are telling conservatives that a convention is the only way to rein in the federal government. These leftists, some of them wearing conservatives' clothing, are using the classic techniques of the left. They are not telling the truth. They are smearing their opponents, and they have divided conservatives. Conservatives all over the country who fell for the marketing have been manipulated to attack and smear conservatives who were warning them of the dangers of a convention. Meanwhile, avowed Marxists such as George Soros and his groups also want a convention. Those of us who were warning of the dangers are being attacked, smeared, and persecuted, and Tea Party leaders who support a convention won't let us address their members. We're at the fork in the road. Should we push for a convention and let others replace our Constitution, or should we do what our framers actually told us to do when the federal government usurps power? Let's look at this 5,000-year miracle. Our Constitution delegates only a handful of enumerated powers to Congress. How many Americans know this? How many Americans can list 5 of the enumerated powers? How many can list 3? How many even know what an enumerated power is? That's the problem: ignorance. Thomas Jefferson said, "You can't be ignorant and free." It is our ignorance of the Constitution and the collapse of personal morality, religion, and personal responsibility which have brought us to the brink of destruction. And you can't fix that by changing the Constitution. When we ratified this Constitution, we created the federal government. It is a federation of sovereign states, united under a national government for those limited purposes itemized in the Constitution, with all other powers reserved to the states or the people. We listed every power we delegated to the national government. Most of the powers delegated over the country at large are listed at Article 1, Section 8, Clauses 1 through 16 on this one little page. All our Constitution authorizes the national government to do over the country at large falls into 4 categories. 1, military defense, international commerce and relations. 2, immigration and naturalization. 3, domestically, create a uniform commercial system, weights and measures, patents and copyrights, a money system based on gold and silver, bankruptcy law, mail delivery, and some road building. And 4, with some of the amendments, secure certain civil rights. That's basically it. All other powers are reserved by the states or the people. This chart, and pick up one before you leave, illustrates 2 principles in our Declaration of Independence and how these principles were implemented in our Constitution. That rights come from God, and the purpose of government is to secure the rights God gave us. In 1776, with our Declaration of Independence, we lit a beacon such as the world had never seen. And in 1787, our framers gave us a federal constitution with a national government whose sole purpose was to secure our God-given rights to life, liberty, and property by means of exercising the mere handful of enumerated powers. And when a government merely secures God-given rights, we are never put in conflict with each other because no one has his hand in anybody else's pocket. It is only with respect to the enumerated powers listed in the Constitution that the national government has lawful authority. If it's on the list, Congress may make laws about it. But if it's not on the list, Congress usurps power and acts unlawfully when it interferes. Depending on how you count, Congress only has 18 to 21 powers over the country at large. If we followed our Constitution, most people could live their entire lives without having anything to do with the national government. So why is our country becoming a totalitarian dictatorship? Because for 100 years, we, the people, and those we elected have ignored the Constitution. Our Constitution is not the problem. Ignoring it is the problem. It was our duty to enforce our Constitution and make our public servants obey it. But long ago, we stopped reading our Declaration and Constitution, and because we didn't know what they say, we were unable to do our sovereign duty to vet, monitor, and discipline our public servants. We allowed our servants to bribe us into surrendering our liberties. That was the purpose of the unconstitutional government assistance programs of the early 1900s, Social Security in the 1930s, Medicare in the 1960s, to demoralize us, strip us of personal responsibility, and make us dependents, so that we would dance to the tune of our servants instead of making them dance to ours. Their tune is tyranny. Our tune is the liberty enshrined in our Declaration and Constitution. The national government has usurped thousands of powers not on the list. State governments have collaborated with the usurpations, and we, the people who ordained and established it, don't have a clue what it says about anything. We don't know that Congress has lawful authority only over those 18 to 21 powers listed, enumerated in the Constitution. We believed the lie that the federal government can do whatever they want, except as limited by amendments. Convention supporters exploit our ignorance when they tell us amendments can limit the powers of the federal government. But when people learn this short list of delegated powers, they can't be deceived by those who tell them that the remedy for a federal government which has usurped thousands of powers not on the list is to amend the Constitution. Think, when the federal government usurps powers not on the list, what part of our Constitution do you amend to fix that? Do we need an amendment saying the federal government can't do things which are not on the list? We already did that. It's the 10th Amendment. They ignore the 10th Amendment. Even so, Mark Levin and Michael Ferris of the Convention of States Project insist the problem is the Constitution. They say the solution is amend the Constitution. They say amendments will limit the power and jurisdiction of the federal government. But our Constitution already limits the powers of the federal government to those 18 to 21 few and defined powers listed in the Constitution. So how can changing our Constitution limit the powers of the federal government when they are doing thousands of things our Constitution already says they can't do? Look at guns. Our Constitution doesn't delegate to the federal government power to regulate guns, gun sales, ammunition, firearms dealers, and do background checks. But they do it anyway. So let's pass an amendment saying they can't do any of that. But we already did. It's the Second Amendment. They ignore the Second Amendment. So the claim that we can control those who ignore the Constitution by amending the Constitution is so absurd they cannot possibly believe it. You may infer from the absurdity of their major claim that they have an evil intent. To those who have been misled by the marketing, I say, God gave you a brain. He expects you to use it. Thinking is a moral responsibility. We know Mark Levin and Michael Ferris don't want to limit the powers of the federal government because the amendments they propose delegate new powers to the federal government or legalize powers the feds have already usurped. Let's look at three of them. Michael Ferris drafted a parental rights amendment he says would protect parental rights. But it does the opposite. It delegates power over children to the federal and state governments. Here is his amendment. Section 3 says, "Neither the United States nor any states shall infringe these rights without demonstrating that its governmental interest as applied to the person," that's your children, your grandchildren, "is of the highest order and not otherwise served." End quote. His amendment repudiates our founding principle that rights come from God and are unalienable, and that the purpose of government is to secure the rights God gave us, and adopts the UN theory that rights come from the government, will be determined by the government, and are revocable at the will of the government. Our Constitution doesn't now delegate power over children to the federal government, but Ferris's amendment gives it to them. Mark Levin's amendments also do the opposite of what he claims. My paper, Mark Levin's Liberty Amendments Legalizing Tyranny, shows how 6 of his amendments legalize powers the feds have already usurped. Levin's amendment to limit the federal bureaucracy legalizes what are now unconstitutional federal agencies. Education, Energy, Agriculture, Environmental Protection Agency, Department of Homeland Security, Housing and Urban Development, Health and Human Services, etc., etc., etc. Our Constitution doesn't authorize these agencies. They are not on the list. But Levin's amendment legalizes all such agencies for as long as Congress reauthorizes them. Article 1, Section 1 of our Constitution says only Congress may make laws. But since Woodrow Wilson, our federal agencies have been writing rules, the Code of Federal Regulations. All these rules are unconstitutional, as outside the scope of powers delegated, and as in violation of Article 1, Section 1. But Levin's amendment to limit the federal bureaucracy legalizes these rules and the rulemaking process for as long as Congress approves them. Levin's amendment to limit federal spending is also phony. Our Constitution limits Congress's spending to the enumerated powers. If you go through the Constitution and highlight all the powers delegated to Congress and the President, you will have a complete list of the objects on which Congress is authorized to spend money. That is how our Constitution controls spending, but they ignore it. Levin's amendment substitutes a budget for the enumerated powers and thus legalizes the current practice where Congress spends money on whatever they or the President put in the budget. The result of Levin's balanced budget amendment is to legalize spending, which is now unconstitutional. It changes the constitutional standard for spending from whether the object is an enumerated power to a pretended limit on the total amount of spending. And the limits on spending are fictitious because they can be waived whenever Congress votes to waive them. You must read proposed amendments and understand how they change our existing Constitution before you support them. Don't go by the names. The names are chosen to deceive you. Levin's and Ferris's amendments institutionalize the abuses they purport to correct, nullify the natural rights of the people, and fundamentally change the constitutional design. Even though our Constitution is not now being enforced, it still declares this government lawless. The rule of law is still on our side, but not for long if we foolishly allow our Constitution to be replaced. The leaders of the Convention of States Project say, we must amend the Constitution because people in Washington don't understand it. Rubbish. Our Constitution is so simple. Alexander Hamilton said, the people are the natural guardians of the Constitution. Hamilton expected us to be able to distinguish between a lawful exercise and an illegal usurpation of authority. Federalist number 16, next to the last paragraph. For clauses the Supreme Court perverted, interstate commerce, general welfare, and necessary and proper clauses, a quick look in the Federalist Papers shows the original intent. We don't need a convention to draft amendments showing what these clauses mean. Look it up in the Federalist, but I've already done it. Here it is on this one sheet of paper, the original intent of those three clauses, proved by the Federalist Papers, and you can have a copy. Now let's look at what Tennessee has done about an Article 5 convention. Between 1902 and 1980, Tennessee sent 14 applications for an Article 5 convention to Congress. In 2010, Tennessee rescinded all these applications with H.J.R. 30. But last year, Tennessee passed an application for a convention, H.J.R. 548. This year, the Tennessee Senate passed S.J.R. 67, the application for an Article 5 convention Michael Ferris is pushing. The House will vote on it when they reconvene. Here are the documents. And by the way, at the end, I'll tell you how you can get copies of all my documents. Talk to your legislators. Once they understand that our Constitution already limits the national government to the 18 to 21 powers on the list, and our Constitution already limits Congress's spending to the enumerated powers, they can see the absurdity of the claim that the remedy for a federal government which ignores the Constitution is to amend the Constitution. For 50 years, leftists tried to get an Article 5 convention. Conservatives stopped them. So the leftists repackaged the push for a convention to market it as an issue of states' rights versus the federal government. They say, we must amend the Constitution to restore powers the federal government has taken from the states. Rubbish. The 10th Amendment says that all powers not delegated to the United States by the Constitution are reserved to the states or the people. What happened to these reserved powers? The states sold them to the federal government. The Department of Homeland Security is nationalizing local and state law enforcement. DHS answers to the president. Tennessee allows DHS to be involved in issuing driver's licenses. In 2004, the Tennessee legislature passed an act putting county sheriffs under the control of the Department of Homeland Security. security. The states went along with the DHS-controlled fusion centers, and local police all over the country are being taken over by the federal government, hooked in by federal money and free stuff. Thanks to the connivance of the state governments, Obama is getting a national police force like the East German Stasi, and we are losing local and state control over law enforcement. State governments are forcing children into federal education schemes such as Common Core. They did it for the federal grant money. I have been informed that the state of Tennessee got $500 million for selling our children to Common Core. According to the Pew report, 39.5% of Tennessee's revenue is from federal funds. The states don't want to cut federal funding. They don't want to cut federal spending. They don't want to lose their federal funds. Last year, Tennessee Senator May Beavers filed an Obamacare nullification bill. But the fiscal note said if her bill passed, Tennessee would lose $6 billion in federal funds. Well, our legislators who preen their moral outrage over out-of-control federal spending didn't want to pass the Obamacare nullification bill because they didn't want to lose their federal funding. By the way, is your state representative here?
He didn't make it.
The next one is.
I wasn't holding my breath.
State governments are not victims of federal tyranny. They are enthusiastic participants in federal tyranny. So we must stop electing people who want to keep those federal funds rolling in. There's no such thing as something for nothing. With federal money comes federal control. Convention supporters fabricated the preposterous claim that our framers said the purpose of amendments is to rein in the federal government if it usurps power. Our framers never said that when the federal government ignores the Constitution, our remedy is change the Constitution. One delegate at the Federal Convention of 1787, George Mason, that's the convention where this was drafted, George Mason wanted states to be able to make amendments without approval of Congress and in a manner which did not depend on Congress. On the last day of deliberations, the convention method of proposing amendments was added. But since Congress calls the convention, and because of the necessary and proper clause in Article 1, Section 8, last clause, Congress has exclusive authority to organize the convention. So George Mason didn't get his way and was one of only 3 delegates who refused to sign the Constitution. Look at the list of signers. George Mason's name isn't there. Yet convention supporters claim that George Mason, one of the 3 dissenters, is the one who called the shots. We must distinguish between defects in a Constitution and a government's refusal to obey the Constitution to which it is subject. There were defects in our Constitution. Slavery. Amendments fix defects. But our problem is a disobedient federal government and disobedient state governments. That calls for different remedies, and our framers spelled them out, and I'll tell you about them. What our framers who signed the Constitution actually said is that amendments remedy defects in the Constitution. that amendment of errors and useful alterations would be suggested by experience, and that useful amendments would address the organization of the national government, not the mass of its powers. Remember, only 18 to 21 powers were delegated to Congress over the country at large. Convention supporters insist that the states will appoint the delegates, control the delegates with state laws, each state gets one vote, and Congress has no power over the convention. The states run the whole show. There's not a word of truth in those claims. I'll show you. Look at the Constitution. Article 5 says Congress calls the convention. A call is the official summons for the convention to take place. It states the date and location, how delegates will be appointed, etc. Article 1, Section 8, last clause, delegates to Congress the power to make the laws necessary and proper to carry out the call. The states have no power over the convention at Article 5. All they can do is ask Congress to call it. And state laws cannot control delegates. Delegates can vote to make the proceedings secret. That's what they did at the convention on May the 29th, 1787, at the convention where this Constitution was drafted. The delegates voted on May the 29th, 1787, to make the proceedings secret. And if the proceedings are secret, and the delegates, if they vote by secret ballot, the states would never know which delegates did what at the convention. It is impossible for states to control delegates at an Article 5 convention. All they have to do is make the proceedings secret, closed to the public, as they did in 1789, and vote by secret ballot. Congress gets its research from the Congressional Research Service, the CRS. Here is their April 2014 report on issues under an Article 5 convention. CRS confirms that Article 5 delegates to Congress exclusive authority over both methods of amendment. The report shows that in Congress's preliminary preparations for Article 5 conventions in the past, Congress has provided that delegates would receive immunity from arrest and has planned to apportion delegates the same as in the Electoral College. So California would get 55 delegates, Tennessee would get 11. And Congress decides who will appoint the delegates. Congress may permit the states to select them, or Congress may decide to appoint the delegates. Convention supporters insist they know exactly how a convention will operate. But page 27 of the CRS report says, quote, "In the final analysis, the question, what sort of convention, is not likely to be resolved unless or until the 34-state threshold has been crossed and a convention assembles." D.C., the Congressional Research Service says we'll have to get a convention before we know how it is going to operate. Convention supporters say a convention is safe because 3/4 of the states have to ratify whatever comes out. That is a lie. Listen well. If another convention is called, the delegates are invested with that inherent sovereign right of a people to alter or abolish their form of government. Declaration of Independence, second paragraph. We've already abolished one constitution and replaced it with another. After July the 4th, 1776, we operated under our first Constitution, the Articles of Confederation. This was our Constitution until this one was ratified in 1788. This is our second Constitution. How did we get from our first Constitution to our second Constitution? There was a convention to amend our first Constitution. Pursuant to Article 13 of the Articles of Confederation, the Continental Congress resolved on February the 21st, 1787, to call a convention to be held in Philadelphia, quote, for the sole and express purpose of revising the Articles of Confederation, end quote. But the delegates ignored this limitation, and they ignored the instructions of their states. These are the state instructions, and they wrote a new constitution. Because of the inherent authority of delegates, it is impossible to stop it from happening at another convention. If we have a convention now, George Washington, James Madison, Benjamin Franklin, and Alexander Hamilton won't be there to protect you. You don't know who the delegates will be, and you won't find out until it's too late. But they will have the power to impose a third constitution. Now listen well. A third constitution will have its own new mode of ratification. Whatever mode will ensure approval of the third constitution. Our first constitution, the Articles of Confederation, required the Continental Congress and all of the states to ratify amendments. We had 13 then. But our second constitution, drafted at the Amendments Convention of 1787, provided at Article 7 that it would require only 9 states for ratification. 13 states and the Continental Congress needed to ratify amendments to our first Constitution, but only 9 states needed to ratify our second Constitution. If we have a convention today, there is nothing to stop the delegates from proposing a third constitution with its own new mode of ratification. New constitutions are already prepared and waiting for a convention. Here are 3. The Constitution for the new states of America is ratified by a referendum called by the President. The states are dissolved and replaced by regional governments answerable to the new national government. The Constitution for the new Socialist Republic of North America, 100 pages of horror. It's ready? The Constitution 2020 movement is funded by George Soros and supported by Eric Holder and Marxist law professors all over the country. They want a Marxist constitution in place by the year 2020. Change agents of every breed have the same goal, a convention, so they can get rid of this constitution and impose a third constitution. If there is a convention The only issues will be whose constitution will be proposed by the delegates and what will the new mode of ratification be. Will it be the Ford and Rockefeller Foundation's constitution, the Constitution for the new states of America, the Communist Party's constitution, George Soros's Marxist constitution? Will it be the rewritten constitution the leaders the Convention of States project have in mind? Or will it be a constitution transforming us from the United States of America to a member state in the North American community with Canada and Mexico? And Heidi Cruz, Ted Cruz's wife, was on the task force for the Council of Foreign Relations, which drafted this. Talk about monumental hypocrisy on the part of some of our candidates for president. So whether Congress or the states set up and organize a convention is not the critical issue, because in either case, the delegates, whoever selects them, are vested with that inherent sovereign power to throw off this Constitution and propose a third Constitution with a new mode of ratification. Just as the delegates to the Convention of 1787 overthrew our first Constitution, delegates to a convention today can overthrow our second Constitution, and you will not like the third Constitution. And remember, a new Constitution has its own new mode of ratification. It can be anything: majority vote in Congress, signature of the President, or, as with the new state's Constitution, a referendum called by the President. Look behind the curtain convention supporters have put up. Progressives, Fabian socialists, have been trying for 50 years to get a new Constitution. That's why they have been pushing for an Article 5 convention, because the only way they can get rid of this Constitution and replace it with their Constitution is to have an Article 5 convention. Brilliant men have warned that delegates to a convention can't be controlled. James Madison, father of our Constitution, said in his November 1788 letter to Turberville that he trembled at the prospect of a second convention, and that if there were an Article 5 convention, the most violent partisans and individuals of insidious views would have a dangerous opportunity of sapping the very foundations of the fabric of our country. In Federalist Paper number 49, Madison warns against a convention to correct breaches of the Constitution. He said the legislators who caused the problem would get themselves seats at the convention and would be in a position to control the outcome of a convention. Former U.S. Supreme Court Justice Arthur Goldberg reminds us in his September 14, 1986 op-ed in the Miami Herald that at the Convention of 1787, the delegates ignored their instructions from the Continental Congress, and instead of proposing amendments to the Articles of Confederation, wrote a new Constitution and, quote, any attempt at limiting the agenda would almost certainly be unenforceable, end quote. Former U.S. Supreme Court Chief Justice Warren Burger said in his June 1988 letter to Phyllis Schlafly, there is no effective way to limit or muzzle the actions of a constitutional convention. After a convention is convened, it will be too late to stop the convention if we don't like its agenda. A new convention could plunge our nation into constitutional confusion and confrontation at every turn. Yet convention supporters ridicule these warnings as fear-mongering. Are there violent partisans and individuals of insidious views among us today? Yes, and they want a convention. But convention supporters assure us that only moral and wise people will be at the convention. Let's look at that claim. There are 3 ways to select delegates. Congress. Does anyone trust Congress to appoint only moral and wise people as delegates? Maybe Bob Corker would be chairman of the delegate selection committee. State legislatures. Does anyone trust state legislatures throughout the country to appoint only moral and wise people as delegates? Popular election. Does anyone trust the people to elect only moral and wise people as delegates? We've done such a great job in electing presidents, members of Congress, and our state legislatures. This is the most corrupt period in our history. Lying, oath-breaking, baby-killing, malice-dripping smearers and responsibility shirking are everywhere, and moral and wise people haven't been in charge of anything for 100 years. So, what did our framers say to do when the federal government usurps power? They never said, when they violate the Constitution, amend the Constitution. They never said, file a lawsuit and let federal judges decide. They advised 2 remedies. The first remedy, elect faithful representatives who know the Constitution. James Madison said, our Constitution depends on the people having the virtue and intelligence to select men of virtue and wisdom to office. But we keep electing people who know nothing about our Constitution. We vote for them because they tell us what we want to hear, and we fall for it. We must vet candidates for office, conduct forums, and test candidates on their knowledge of our Constitution. Grill them. Study the handout chart you'll get, and the Declaration and Constitution until you know what they say. This is not difficult. We cannot be ignorant and free. Here is the list of what Congress is authorized by the Constitution to spend money on. It's these bullet points. Look how short the list is. This is why our framers envisioned running our country on import tariffs. This is all they can spend money on, and you'll get a copy of this. Any candidate who supports a balanced budget amendment doesn't know that our Constitution already restricts spending to these items, or he thinks the feds ought to be able to spend money on whatever they want. The second remedy is nullification. Alexander Hamilton, Thomas Jefferson, and James Madison said, when the federal government does things which are not on the list, each state has the natural right to nullify of their own authority all such acts of the federal government. I'll show you why the states have this natural right. Where did the federal government come from? It was created by our Constitution. Who ratified the Constitution? We, the people, acting through special ratifying conventions called in each of the states. So the federal government is merely the creature of the Constitution and is completely subject to its terms. That is why the states as the creators of the federal government and of this constitutional compact between the states. That is why the states are the final authority on whether their creature has violated the constitutional compact the states made with each other. That is why states have the natural right to nullify unconstitutional acts of their creature, the federal government. Does the creature dictate to its creator? No. So when the federal government asks the states to do things which are not on the list, the proper response is either no or hell no. The Declaration of Independence says at the 7th paragraph that the colonials opposed with manly firmness the king's invasions on the rights of the people. We must restore manly opposition to violations of our Constitution, and we are starting to see it. Hundreds of nullification bills are being filed in state legislatures. The 10th Amendment Center website keeps you up to date. My exhibits prove everything I said. If this were a jury trial, you would now be sent into the jury room with my exhibits. But if you contact me, and my contact information is on the handout sheets, contact me and I'll send you a list where you can get hyperlinks. I'll give you the hyperlinks to all of my exhibits. And now I will answer your questions about the Constitution and tonight's topic. You can clap now.
Okay, what can we do at our little level down here that we are at? What can we do to affect those things you talked about? Where do we go? Who do we start talking to?
Well,
I don't know if voting wise and prudent people in is going to make it. We're too far down the line.
nullification is catching on. Now, the convention supporters badmouth nullification and the people who teach you about nullification, because the convention supporters want you to think that our only alternative is to have a convention and amend the Constitution. But in spite of that, nullification is catching on. I have a paper on nullification. It's short and it's simple. If you contact me, I'll send you the hyperlink. It's very simple. I cite, I quote, and provide hyperlinks to original source documents, writings of Alexander Hamilton, Thomas Jefferson, and James Madison, the father of our Constitution, proving that nullification is the remedy they advise when the federal government usurps power. If you use my paper as a resource, you can astound your friends and confuse and confound your enemies. You can win every argument against the nullification deniers. So teach nullification and push nullification. Manly men and womanly women refuse to bow down to tyranny and to unconstitutional laws, just as that noble county clerk in Kentucky did.
Amen.
The Supreme Court has absolutely no jurisdiction over marriage. How do we know? Marriage not on the list.
Yet people think just because the Supreme Court said they can get married in all 50 states, they think it's the law. It's driving me crazy.
I know, it's driving me crazy. I graduated from law school over 40 years ago. Even then, we were taught in law school, and lawyers indeed have been taught this for most of the 20th century, that the Constitution means whatever the Supreme Court say it means. We were taught that the Supreme Court is the sole and final authority on the meaning of the Constitution, but that is a huge lie. Look at the Supremacy Clause in Article 6, Clause 2. It lists 3 things which are part of the supreme law of land. The supreme law of the land, the Constitution, acts of Congress made pursuant to the Constitution, and treaties made under the authority of the Constitution. Supreme Court opinions not listed. On my website, and my Facebook page, I posted, 3 paragraphs on this, and it's already gotten 6,000 views, and it is being copied all over the internet. So it's a matter of what I've had to learn how to do is to explain things very simply and shortly so that people can understand them and then teach them. And it is getting spread. Yes, sir?
2 things real quick. If I understand it correctly, Article 3, Section 2 allows Congress to limit the jurisdiction, the appellate jurisdiction of the Supreme Court. And they've done that as recently as the 1990s. So a lot of the stuff that the Supreme Court does, the Congress could have prevented them from even seeing, from it even coming to them. But they don't want you to know that because they would much rather you blame the Supreme Court and they can say, hey, the court did it, I can't help it. Is that, am I misunderstanding something about that clause?
That is commonly said, but it isn't strictly accurate. I've written a paper on it. I need to write another one, making it more
Didn't they do
easy.
that in the 90s though? I read that they did that with some prison legislation that they wrote, the Congress wrote, and that they removed the authority of the Supreme Court to review that particular, that legislation.
Well, many things are passed in Congress. Most of them are unconstitutional. A few of them are constitutional. So just because they did it doesn't mean it's lawful. It's a little more complicated than that. But basically, the jurisdiction of the federal courts is established at Article 3, Section 2, Clause 1. That lists the categories of cases the federal courts are authorized to hear. Congress cannot reduce that list because that list is established by the Constitution. What you're talking about basically has to do with the federal rules of appellate procedure.
Yeah, appellate jurisdiction, not the original jurisdiction.
No,
We're talking about appellate jurisdiction.
No, I'm talking about the rules of appellate procedure. These are the rules. It's talking about the rules of appellate procedure, not the subject matter jurisdiction of the courts.
Okay.
It's a popular misconception. Contact me and I'll give you more information about it. My email address will be on the handout.
Yeah, you're not hard to find, but yeah.
I'm easy to find.
But one other thing, the 10th Amendment, it says the rights that are not enumerated, and I'm paraphrasing here, the rights that the federal government were not, that they weren't given, everything remains either with the states or with the people.
Yeah.
Okay, well, our states are about as pathetic as the Congress.
They
as
are.
you say, they're complicit.
Yeah.
So, and a lot of these things, I know we couldn't do, but why couldn't the people do, like for instance, the people of the state of Tennessee do a class action lawsuit against our state for not interceding between us and the federal government or something?
If you want justice, the last place to get it is in court. Our judicial system is corrupt, and our framers never recommended that we run to court every time that could cause problems. No. Our framers recommended voting the bastards out of office and nullification of unconstitutional acts. They never recommended filing a lawsuit. Basically, that's responsibility shirking.
Okay,
People need to vote them out of office or nullify it.
is nullification impeachment? Or are we talking different things here?
Oh, they're totally different. Impeachment is how you get rid of someone in the executive branch or in the judicial branch. They can be removed from office via impeachment, trial, conviction, and being kicked out of office.
Okay.
Nullification is where a state, or in some cases individuals, say, that law is unconstitutional, we will not submit. For example, the civil rights laws, these were the Jim Crow laws. These were state and local laws enforcing segregation. Martin Luther King, Rosa Parks said, we will not comply. That's nullification on an individual basis. The Connecticut Constitution says, every citizen has the right to keep and bear arms in defense of himself and the state. So a year or so ago, when the Connecticut legislature passed a pretended law requiring everyone in the state to register his firearms, and it's a felony if you don't, that state law was unconstitutional as in violation of the Connecticut Constitution. Because under the Connecticut Constitution, if you are a citizen, you have the right to keep and bear arms in defense of yourself and the state. So, a great many brave citizens of Connecticut nullified that pretended state law and refused to register their firearms. That's another example of individual nullification of unconstitutional state laws. And then
Isn't that what Davis did? Davis, she's the gal in Kentucky.
But in a sense, yes. The Supreme Court's opinion was totally unconstitutional as outside the scope of powers delegated to the federal government. Marriage is not on the list. Oh, let me tell you how the Supreme Court arrived at that opinion. Section 1 of the 14th Amendment. That was one of the Civil War amendments. The purpose of that amendment was twofold, Section 1 of the 14th Amendment. The purpose was to extend citizenship to freed slaves and to protect them from Southern black codes which deprived them of basic God-given rights. It uses the word liberty. In 1973, the Supreme Court looked at the word liberty in Section 1 of the 14th Amendment. Now bear in mind, the purpose of this section, extend citizenships to freed slaves and protect them from Southern black codes. But in 1973, the Supreme Court looked at the word liberty and said, oh, liberty means privacy, and privacy means you can kill your baby. That was Roe v. Wade abortion. A few years later, in State v. Lawrence, the Supreme Court looked at that same word, liberty, and this time redefined it to mean homosexual acts between consenting adults in privacy is a liberty right protected by the due process right of the 14th Amendment. And then in the marriage case, they looked at the due process clause and the equal protection clause in Section 1 of the 14th Amendment and said, this time it means homosexual marriage is a constitutional right. So, do you see, the Supreme Court looks at words in the Constitution and defines them and redefines them and redefines them again to get them to mean whatever they need them to mean so they can get the result they want in the case before them. So, when the Supreme Court ruled in this marriage case, their acts were totally unconstitutional, without authority, usurpations of powers not violated, and yes, Kim Davis nullified them by refusing to submit.
So it would take the states to do the nullification. So we could just say, heck no, we're not going to go. We're not going to have this business
Well,
here
it's
in
a
Tennessee.
little more complicated because of the Federal Civil Rights Act. Congress passed the Federal Civil Rights Act, and it's now being used Kim Davis was sued under the Federal Civil Rights Act, and she was sued not only to force her to submit, but she was also being sued for emotional damage. You see, the homosexuals to whom she denied marriage license, their feelings were hurt so much, they were so severely damaged emotionally that they need to be paid this buku sums of money solve their hurt feelings.
And they're probably not mature enough to be married to anybody.
You know, that's just what I was thinking. If they're that emotionally unstable, they really shouldn't be getting married.
They'd be dangerous married to a tree.
This is probably off the subject, but in that same Supreme Court, I know it was illegal for them to even hear that, but was it not that two of the justices should have recused themselves anyway because they had performed homosexual marriage?
Yes, Ruth Bader Ginsburg had performed one shortly after oral arguments, and I think the other.
Kagan.
Yeah, Kagan had.
There's a federal law on that, if I'm not mistaken.
Well, we're at the stage in our country where law, in the high sense of the word, is evaporating faster than an open jar of rubbing alcohol in a desert.
Back to my earlier.
So that really means nothing because it wasn't really supposed to be there or shouldn't have been there in the first place.
The law is meaning nothing. It's being ignored on such a massive level, the true law.
The Constitution never gave any of the courts the right to legislate in the first place.
That is
but
correct.
that's exactly what they're doing and have been doing for decades.
Yeah,
Nor the EPA or the,
they're not on the list.
yeah.
Since there is no actual law stating that marriage is, and Congress has not passed a law that says that marriage is between whomever and whomever, as it stands right now, it's between a man and a woman, Davis would have actually been violating state law, which states
By doing it.
that
yeah.
marriage is between a man and a woman if she had issued those. So in essence, she would have been breaking state law if she had issued those.
Our framers would say you're absolutely correct. But today, we are all laboring under the misapprehension that whatever the Supreme Court
I understand that, but
says.
they didn't make a law,
Okay, now,
and neither did Congress.
let's talk, does Congress have authority to make a law defining marriage for the country at large?
No.
No, but they did have a DOMA. But they did have a DOMA that said that it was left up to the states.
Yeah. But, did Congress have authority to pass DOMA? No. Marriage, not on the
No, I
list.
understand. No, I do understand that.
Yeah.
So therefore, it actually reverts to the state.
Marriage, homosexuality, abortion, all that stuff.
To the state.
Drugs.
That's what he's saying is the state has a law against it. So-
Right, yeah, I know.
So
I know.
therefore, she would have been
Kentucky law.
violating state law.
Yeah, yeah.
Just
It's just
normative.
that the prevailing dogma among lawyers
Oh, I understand.
is that as soon as the Supreme Court burps, that changes everything instantly in the country. Of course, it's wrong, but that's what people believe. And that's what lawyers believe, except for this lawyer and a handful of others.
Can you talk about jury nullification?
Well, I said bullets.
Okay, our framers had no dispute that in a criminal case, jurors have the right to judge not only the facts of the case, but also the constitutionality of the statute under which the defendant is charged. If you look in Noah Webster's 1828 dictionary under the heading jury, he talks about how jurors in criminal cases have the right to judge the law. Alexander Hamilton wrote at length about jury's rights to judge the law in criminal cases. But somewhere along the line, and I don't know when it was probably a gradual process, but certainly by the time I was in law school and by the time I started doing criminal trial defense work, the defense counsel were no longer allowed to tell jurors of their right of nullification. In fact, if we attempted to hint to juries about their right to judge the law as well as the facts, Your Honor, objection, recess, the prosecutor would object, the judge would send the jury out, and the judge would blast defense counsel for even daring to mention that and saying one more word out of you and I'll hold you in contempt. And when a judge holds you in contempt, you go to jail. So defense counsel are no longer allowed to tell jurors of this right, and furthermore, when the judges are questioning jurors before they start hearing the evidence, the judges require the jurors to swear that they will apply the law as the judge explains it to them. So, although the right of jury nullification still exists in the sense that if you get a smart juror on your criminal jury, you can still get nullification. Defense counsel just isn't allowed to tell the jurors about it.
But isn't that person quickly kicked off by prosecution?
If he opens his mouth, yes. But
That's
the
what I mean,
way you
but
could
you're-
get around it would be, say I'm a prospective juror, and the judge says, now, do you promise to apply the law as I explain it? Well, I could say yes, because I assume that what the judge tells me is going to be true, right? But if later on, to my shock and horror, after I've taken the oath, I learned that what he told me isn't true, then I must follow my conscience.
Subject of judges, they're making their own laws according to their agendas throughout the country.
Yes.
So what do we do about it?
It may be too late to turn our country around. The moral corruption and the ignorance are widespread. They're almost universal. It may be that what we should be doing is preparing for the worst. The only reason I speak is because I'm called to do it, and because of that passage in Ezekiel. If you see danger coming and don't warn of it, their blood's on your hands. Yeah, so, I mean, that's the only reason I do it. Do I have hopes of changing? Well, I don't know. You know, our job is to do what we're called to do, to be obedient to God, and to leave the results in His hands. We don't know what's going to happen. I mean, look how Kim Davis, look what she's accomplished.
Look at how popular the prophets were when they did bring the message before the people.
Yeah. Yeah.
After he died, his sister.
My only hope is that she refuses to do what they have commanded her to do.
They are, did you hear what they're doing?
They told that she cannot stop the deputy clerks.
Yeah.
But her being the overall clerk, she is in charge of all the deputy clerks, I'd still tell them, no, you cannot do that.
But her name is on that license too. I
Exactly.
think that's why.
They're going to take it off.
Well, they're not, and the license aren't going to be actually totally legal because her name isn't on it, because the deputies can't do it without her signature, but the
They take state law to
licenses
change that.
that they do, that, the licenses that they send out
Again,
aren't
it's
going
state law.
to be legal.
A lot of people are looking to 2016 to save the country, but there's some unconstitutional candidates out there, in my opinion. What's your thought on that?
I don't know of any candidate on the national level who has a clue about a constitution.
No, I mean unqualified constitutionally speaking.
The criteria
The natural
for being
born
a
issue,
candidate.
the natural born citizen issue.
Oh, well, Ted Cruz is clearly not qualified. Who else?
Rubio.
Oh, Marco Rubio is not
Obama.
qualified. Oh, of course, Obama is, yeah.
Oh, where was all this in 2007?
They've been pushing it down, and that's the problem. That's the problem with expecting the media to carry the weight, because they won't. They're in cahoots with Washington. So
They are.
Yeah.
They're as loyal to Washington as Pravda was to the Communist Party.
Indeed.
It's just an organ of the national government.
You had said vote the bastards out. Well, okay, last election, we got GOP in,
Yeah.
they won't do anything, so the whole bunch is bastards.
No, we voted the bastards in.
Yeah. Unknowingly.
See, I can listen to Republican candidates. I know the Constitution like the back of my hand. Everybody in this room could know the Constitution like the back of their hand because it isn't difficult. Once you understand the enumerated powers on our federal structure, you can listen to any of those national candidates, any of the state candidates, and realize they don't know what they're talking about. For example, the balanced budget amendment. Aren't all the Republican candidates in support of the balanced budget amendment? Well, that shows they don't have a clue that our Constitution already says what they can spend money on. If it's not an enumerated power, how can they appropriate funds for it? Where is education in the Constitution? Nowhere. Where is environmental protection? Nowhere. Where is health care? Nowhere. None of this stuff is in the Constitution. So how can you spend money on it? You can't lawfully spend money on.
Federal Reserve.
Everybody wants everybody to have health care.
Well, see, that was the purpose of the Federal Reserve Bank. In order to transform our country from a constitutional republic to the regulatory welfare state, which was set up in the early 1900s, they needed an unlimited source of credit. And that's what they got from the Federal Reserve System. That's why they voted it in.
As bad as our current president is, he doesn't hold a candle to Woodrow Wilson.
They're both,
But we are suffering today because of what Woodrow Wilson started.
yeah, and what's his name?
Although his last year in office, he never really regained confidence. He suffered for what he did.
Good.
Most people don't know that.
Teddy Roosevelt was no.
No,
Yeah.
he wasn't either. I'll agree.
Roosevelt.
Yeah, but none of them were pro-Muslim, so that makes this guy
That is
worse.
true.
And none of them actually hated America. I
Well,
don't think. And I think this guy wants to
Income
bring
tax
it down.
bill was never ratified.
Well, I've heard it too, but,
So,
in a sense, whether or not the 16th Amendment was legally ratified, in a sense, that's irrelevant because everybody acts as if it was legally ratified. The courts act as if it's legally ratified. Now, I didn't do criminal defense tax law, but the criminal defense tax lawyers are not even allowed to make that argument because the courts have rejected
It wasn't
it.
ratified.
So defense counsel are not allowed to say that. They can't argue that. The courts won't let them.
What surprised me is when the same-sex was passed, many people who were against it said, oh, well, it's the law now. And it's not. No, it's not the law. They just rolled over and said it is what it is, and I don't understand that. I don't understand where the outrage is.
Well, be very careful about the language. You said when it was passed. It was
Yeah,
never
it was
passed.
passed.
Yes. The Supreme Court issued an opinion.
Yes.
It wasn't law, it's just an opinion. It's not part of the supreme law of the land. It's just their opinion. The lawyers were told that Supreme Court opinions are law. That's what we were told. But if you look at Article 6, Clause 2, you see that's a lie. But still, the lawyers are so tightly plugged into the matrix that you cause them serious emotional breakdown when you challenge something like that.
But the Supreme Court said they were. I mean, you know.
Yeah.
Most
And I'm
brilliant
thinking that's-
lawyers there, when you and my life, I heard him give a speech over 30 years ago. And he explained to everybody that was present, we had a pretty good crowd in the room. He said, if you people keep electing lawyers, to be your representatives and your senators, he said, you're dead in the water.
Or bankers.
He absolutely said that's the biggest mistake you could possibly make, because he said, if you don't think they go further than this, you know, you're as wrong can be, and they don't care whose rights they step on in the process.
Well, unfortunately, that fault is not limited to lawyers.
Oh, I
It
know.
seems to be pretty universal.
I know, but when you
Today.
look back over time, we have always had a rather large representation from the legal community and.
Yeah, but then, Thomas Jefferson and James Madison and
Oh,
Alexander
yeah.
Hamilton,
Oh, yeah.
But even now,
We no longer-
our CEOs from corporations now, they're all against us.
They are.
We no longer
They're
elect.
globalists.
Yes.
What happened is we have career politicians.
We no longer elect
They never
statesmen.
leave.
We elect politicians.
Right.
And most people don't even know the term
Right.
statesman.
We elect
Right.
people who tickle our ears.
Yeah.
But we have politicians funding other politicians in other states against us also. How is that? How is that allowed? It just doesn't make sense. They can get away with this.
Every time I come to one of these meetings, I feel like going out and jumping off of the bridge.
Listen, this thing with Kim Davis, I've been encouraged to see the reaction on the internet. I'm seeing lots of people
Yeah.
saying
And-
Supreme Court opinions aren't law.
And the reaction of people in Kentucky.
Why does she know
The
more?
ones that rallied to her support.
How
That's,
many other people should?
that's something you don't see too often anymore. There was hundreds of people there outside the jail. But that was actually a good thing to see.
I'd like to see videos. Do you have a video?
I just saw maybe the Newsmax,
Oh,
I believe.
well, I'll look for it. I'd like to see a video of it.
For just a couple of days. It was actually on CNN too. believe it or not.
Oh,
The Communist News Network?
oh, the handout sheets.
Could you, let me help you hand those out. If you can send all of your links to me, and I can send them to the
Okay.
entire group, I'll hand these out. We have something, an update on some of our events. We're trying
Okay.
to impeach the president,
Okay,
get rid of his ass and all his ilk.
okay.
We'd like to, if I could real quick, my name's Dave Vance. I'm involved not just with this group, but with an organization called Constitutional Accountability Coalition of Tennessee. I know this may sound crazy, but there is an effort underway to impeach the president. Now, here's the deal. We already have a handful of reps who have seen the articles. The articles were written by the North American Law Center. All right, and we already have a couple of reps who saw them and said that when they got back from recess, at a certain point, that they would submit these articles of impeachment. Now, whether or not they will follow through on that, I don't know. But I want to just kind of reiterate the actual process. It's not like a typical bill. Any one representative can present articles of impeachment. It goes to the House Judiciary Committee. You only need 21 of the 23 Republicans on the House Judiciary Committee for it to go to the full House. It goes to the full House, you only need 218 to pass, okay? You don't need any Democrat help to impeach the president. But remember, the impeachment that's an indictment, okay? That's not removal. To remove or to do anything like that, it has to be done in the Senate. Now, if they do follow through, and I can't tell you their names or where they're from, because if I tell you where they're from, you'll pretty much figure out who they are. All right, and it's not time, so here's the deal. Once this happens, if they do actually follow through and present these articles, it's a whole new ballgame. Because just ask yourself, even the Rhino Republicans don't want to be on record as having an opportunity to impeach this president and vote not to do it. Okay? So, if they do impeach him, it goes to the Senate, that's where everybody says, well, the Senate will never do it. Understand, these are going to be televised. This is not going to be like all the secondhand information we get with all these other committee meetings, or these other interrogations that they do in committee. This is going to be televised.
It's required by law
It's required by law to be televised.
on all channels.
And so, more people are going to find out about what's been going on in this administration and what currently know about, that a lot of people don't keep up with it like we do. So, you've got that. Not to mention, these articles were not framed, they were not written like the articles that they tried to take Clinton out with. They're more like the ones that they got rid of Nixon with, okay? constitutional scholar named Stephen Pidgeon is one of the guys who helped write the articles. These weren't just these. This was not some Tea Party that got together and wrote articles of impeachment. Okay, all right. These were serious people that wrote the articles, vetted them. They list all the charges, all the U.S. codes broken, the parts of the Constitution that were broken. And so, if he gets impeached and makes it to the Senate, do not count on the normal Senate math that you hear about, saying, "Oh, well, there's no way," because in something like this, it's never just the top guy. Do you think Obama got away with everything he's done by himself? Do you think he did not have help? Okay, so when people tell you, well, it's a waste of time because the Senate will never do it, just remember, the Senate serves as a jury. If you're on trial, you cannot also be part of the jury. Okay, so you're going to have to read between the lines here a little bit of what I'm trying to tell you, but do not believe the typical, "Oh, well, they don't have the numbers," because that's not necessarily the case. So, I'm not telling you this is going to happen. I am telling you that there were at least 2 reps that said they would file. There were several others who said they would support it. And once again, it's not a bill, cannot be filibustered. If I say anything constitutionally incorrect, I'm sure she will correct me. Okay? It cannot be filibustered. They can't add a poison pill amendment to it. Like I say.
The jury can say nothing.
Right.
How many states are part of this?
We have, the coalition started, the first national con call was on the 29th of June. We now have 25 states that have chapters. Okay, now, we're not talking huge numbers, but it really does, once this ball, if these guys follow through on what they said they were going to do, as soon as that makes the news, it's a whole new ballgame. So,
You should also explain that Boehner has no option.
Oh, right, yeah, neither Boehner or McConnell has the option of saying, "Oh, no, we're not going to do that." Now, think about it, right after the election last year, what was the first thing out of Boehner's mouth? Impeachment off the table. Well, he doesn't actually have the authority to take it. I'm not saying he doesn't have influence, but he does not have any means of saying, "We're not doing that." If you have a rep who has these articles and he's decided he's going to file them with the House Judiciary Committee, he's going to file them with the House Judiciary Committee. So I think Boehner was trying to basically bluff them, just try to, because he was afraid that right after some might do that. So that's why I was thinking about it. Nobody was really talking at that point a lot about impeachment, but the first thing out of his mouth was, "It's off the table." Right? So Boehner can't stop it. If it gets through the House, McConnell has no choice because the Senate becomes a jury, and it's the Chief Justice oversees it, not McConnell. So, let's see if this comes to pass. I can't tell you that it's going to. I can only tell you that we had at least 2 that said they would file, and several others who said they would support it. Because even though it only takes 1, nobody wants to be the Lone Ranger on something like that. They want to know that they have some support. And we did speak to our representative a couple of weeks ago. We went to Marshall Blackburn's office and spoke with her. I mean, we told her all the things that they had said. And not that she's an oxygen thief, I've never implied that. But anyway, she did say, "Well, the Senate won't do anything." And here, my response was this: okay, number 1, I'm not asking you to do the Senate's job. I'm asking you to do your job. Okay, and by the way, I asked her, "How many times did you vote for Obamacare to be repealed?" Knowing that it was not even going to get voted. There was not even going to be a vote in the Senate. Reid was not even going to, but yet you voted for it numerous times. So I'm only asking you to do your job. Now, if you go to our site, because we still need to push on this, it's CACTN. Does everybody have this information that I sent around? I will resend it again if you do not.
I don't.
Okay, I will send it to you.
I may want to stress that if this ball does get rolling,
Right.
that's when everybody has to contact their individual representatives. Because when you do it in mass, they have no choice.
Right.
If it trickles in 1 or 2 at a time, they can care less.
Right.
But when they are inundated with emails, phone calls, and letters, written letters, they have no choice.
Well, we have a packet. If you go to the website, we have a call to action packet. It lays out the articles. It lays out the constitutional responsibility of the representative. As a matter of fact, your representative, if he knows something has been, if
It's called misprision of treason. If you know treason has been committed and you don't do anything about it, it's called, you're essentially, and I read that to Marcia, she didn't really like that.
Yeah.
So
Issues.
if you look at this packet, it lays out the charges, it lays out all the codes involved, all the federal codes, all the constitutional clauses. So
There's 13 pages of printed materials for the letters,
yeah, but
if not more.
if you can send that, and what we did is we actually mailed it and got a receipt from the different reps. We took ours, took it to Marcia personally, but we sent it to others. So anyway, that's the deal. He's going to send it back out,
Yep.
fill the packets out, send them to.
Let's give a big hand for our speaker.